We're ready to start the first panel discussion of the day. My name is Margaret Ann Wilkinson. I'm the Director of the area of Intellectual Property, Information and Technology Law at the University of Western Ontario. And it's my pleasure to be your chair for this first panel of the day. We will be asking our panelists to speak one after the other for 15 minutes each, which will allow you a lot of time to bring the ideas together in discussion and questions afterwards for about half an hour. It's my great pleasure at this moment to introduce Renata Watkin from the University of Ottawa. She is a doctoral student here under the supervision of Professor Skaza. All the biographies are available to you in the booklet that you just received on registration. And Renata will be speaking on placing geographical indications on the map. Renata.
Thank you. Thank you. I would first like to thank Professor Skaza and Professor Martin Barito for inviting me to be participating in the symposium. I think it's a great opportunity to be exchanging views on emerging issues in trademark law. Most of the literature and commentary about geographical indications in Canada has focused on the implementation of Canada's international obligations. First, okay, all right, thank you. So, as I was saying, most of the commentary and most of the academic literature as well about geographical indications in Canada have focused on the implementation of Canada's international obligations. First, with the TRIPS agreement, with the implementation and the adoption of the concept of protected geographical indications for wines and spirits, and most recently with the implementation of CETA, with the extension of the category of protected geographical indications to agricultural products and foods. I find it very interesting and very telling that in the debates in the House of Commons and the Senate over Bill C-30, which is the bill that implements CETA, most of the comments about geographical indications have all expressed concern with the impact of protecting European-based GIs on the Canadian industries involved, such as the dairy industry. There were only a couple of interventions and questions from two MPs regarding the fact that Canada's list of geographical indications is empty. There's no Canadian geographical indications to be protected under CETA, whereas the European Annex has 173 listed geographical indications to be protected by Canada. And when asked by one of these MPs why there's no Canadian geographical indications listed in the Canadian Annex, the senior trade negotiator for Canada responded, and I quote, that there wasn't a lot of strong interest on the part of Canadian producers to get this kind of protection. Many of the Canadian producers of these products rely on trademark protection rather than geographical indications, which is more of a European type of concept, end quote. I believe that this is a very narrow view of how origin-specific products are protected in Canada. And the reason I think it's a narrow view is because there are many ways under our current legislative framework in which GIs can be protected in Canada. Not only trademarks. You have, for instance, the tools under the TMA from official marks, the passing off provisions that apply to geographical indications at common law, You also have certification marks, and there are also the protections that are available under provincial laws. And with the forthcoming passage of Bill C-30, you will have one more legal instrument to be added to all of these legal tools for protecting GIs. And I believe that the variety of legal instruments and the different degrees of protection, and each one of these provisions in the TMA, for instance, has a specific test for confusion. Some don't admit any confusion into the analysis, like the concept of protected geographical indications for wine and spirits. And some of them can be challenged. There's an objection procedures. Some of them can't, like official marks. Very difficult to challenge official marks unless you start a judicial review process. And I believe that this fragmentation and this these many ways in which these geographical indications can be protected is a real cause of uncertainty and a real cause of confusion. And the purpose of my presentation is to examine these legal tools for the protection of GIs in Canada, but from the point of view of endogenous geographical indications. And I will be focusing on agricultural products and foods, because that's where our system is heading, and that's where international negotiations are happening now. And I will adopt this perspective from Canadian geographical indications, and by doing that, I hope that I will contribute to placing these geographical indications on the map. I realized when I was preparing this presentation that the biggest challenge for me is how to express confusion, how to explain this confusion in a clear way and in 15 minutes. So the plan for my presentation is as follows. I will deal with the tools available under the Trademarks Act first, and I will start by the most confusing of all of these, which is the concept of protected geographical indications for agricultural products. And then I will move to the provincial framework, and I will use specifically the Quebec legislation on the topic. And then I will use as a case study the first Canadian geographical indication, which is the Agneau de Charlevoix, or Charlevoix lamb, which was approved by the Quebec government in 2015. Well, geographical indications are signs that designate products that they have a specific origin, and that origin, that geographical origin, imparts characteristics into these products and make them unique. And so the concept of geographical indications is very linked to the notion of terroir. And terroir is understood now as the natural and physical environment of where the product grows, combined with the human elements like the know-how and the traditions accumulated over the years on how to understand how to deal with the environment, with that physical environment. The challenge with geographical indications is that they are similar in a way to trademarks in that they signal the origin of products. But they do not signal trade origin, but they signal geographical origin. But they do more than trademarks because they also serve as agricultural policy instruments, instruments of rural and territorial development, and also tools that could be used for environmental protection, more specifically for conserving biological resources. And it's this multifaceted nature of geographical indications that makes it so challenging in Canada. First of all, as we all know, the Trademarks Act is federal legislation. However, the power of agriculture is shared between the federal government and provincial governments. To complicate matters further, whenever you're talking about territorial development, you're more in an area of provincial jurisdiction. Now, when we look at the definition of geographical indications, you will see the division of power issues that it raises in Canada. First of all, the process of identification and recognition of these geographical indications involve different jurisdictional issues at every step. Now, for the assessment of the essentially attributable characteristics of these terms, of these products falling under these terms, you have provincial jurisdiction. They seem to, the recognition, the identification and recognition under provincial jurisdiction. At the same time, when you're assessing the reputation of a product identified by a certain term, you're talking about both federal and provincial jurisdiction, because the Federal Trademarks Act protects reputation and goodwill, but also the common law tort of passing off also recognizes goodwill, reputation and goodwill. Now, where a product's renown or reputation is linked to a production process, then it would be more in an area of exclusive provincial jurisdiction. And this can be illustrated by the controversy over ice wine between Quebec and Ontario, because the federal government adopted a regulation on ice wine that says that ice wine is made from grapes that are naturally frozen on the vine. But it was up to the provinces to put more detail into this definition by defining the areas where ice wine grapes would grow, the temperature under which these grapes have to be for them to be harvested, and all the specifications pertaining to ice wine. And Ontario leaves the grapes on the vine, as you know, that's the normal definition. And then when it's -8 outside, the harvest is done and the grapes are pressed, and that's how ice wine is made. Now, Quebec uses a system of suspended nets. They harvest the grapes in the fall, they put the grapes on nets and leave the nets hanging over the vines. And for Quebec, this is leaving the grapes on the vine until they're frozen. And they take the nets with the grapes, and you cannot say that they are wrong in adopting this method of production, because that's within their jurisdiction. But it just shows you how complicated it is to come to an agreement, like a harmonization and agreement in this area. Now, I was going, time is pressing, I was going to go through all the instruments in the TMA. The only novelty here is the notion of protected geographical indications under Bill C-30, and it, if I can go over quickly, it covers categories of food and agricultural products that are in a schedule. They are preset, okay? They are, and this schedule joins. It's a combination of the CETA products and the South Korea, the products that Canada agreed to protect under the Canada-South Korea Agreement. Now, there's an issue with the concept of responsible authority. It raises constitutional issues as well. In provinces where there is a framework, an existing framework for identifying and recognizing these geographical indications, it would be accepting requests for recognition of geographical indications from organizations that are outside the process, the provincial process for recognizing these geographical indications would be overstepping the provincial government's jurisdiction. I will just go to Quebec's, very quickly to Quebec's legislation. It's in a way based on the European model. There is an agency, the Council for Reserved Terms, Reserved Appellations and Specialized Terms. And some products, there are basically 3 products. Oh God, I'm going backwards, right? There are basically 3 products that have been protected, and one of them is the Canadian Ice Cider, Quebec Ice Cider, sorry. The other one is Quebec Ice Wine, Vin de Glace du Québec, and the other one is Agneau de Charlevoix. And you will notice that I know the problem, the request for recognition of ice wine to become a geographic indication is pending. It hasn't been decided at the federal level, and the request in Quebec Ice Cider is both an official mark and a certification mark, and unfortunately, I think it was a case of missed opportunity because it could have been part of CETA. It could have been part of the CETA annex, but somehow it didn't make it to the annex. In the case of Canadian Ice Wine, the Quebec Ice Wine, it's trying to get the certification as a protected geographic indication, and Agneau de Charlevoix currently is protected under provincial law. It's not protected under the Trademarks Act, and both of these products could have made it into the CETA annex, but unfortunately, I think that the narrow view that there's no interest, or that Canadian geographic indications are only protected through trademarks, prevented that from happening. And I do believe that a way to sort out of this confusion, I have established 5 parameters in which, if you have a geographical indication that you could be looking at in order to establish where should you go? Should I have an official mark? Should I have a protected geographical indication for agriculture? And I believe that the official mark still is the best way to protect Canadian geographical indications, but it wouldn't protect Canadian geographical indications abroad. So in order to be protected abroad, geographic indication would have to be a protected geographical indication under Bill, the forthcoming Bill C-30. So to conclude, this is very confusing, okay? There are division of power issues that stand in the way of the development of these geographical indications. There is confusion, and no pun intended, because we're talking about trademark law. There needs to be a simplification and harmonization of these instruments. And as I was talking to Professor Wever before my presentation, and he mentioned that the house needs to be cleaned before we actually be able to adequately protect geographical indications. There is a lot of uncertainty and a lot of confusion. But thank you very much.
Thank you very much, Renata, for opening up our panel on geographic indications. It's now my pleasure to introduce Dr. Marcia Cadogan, a postdoctoral student at the Center for Innovation Governance, for International Governance Innovation, CG, just down the road from us at Western Law. So without further ado, she's going to speak to us on the game changers to geographical indication rules in the global IP system and its impact on Canada.
Thank you very much. It's a pleasure being here, and I'm very thankful for the organizers of the event. It's a very timely event. Renata has started off with a very, interesting engagement on what GIs are all about, and so I will not repeat what she's already said, but my discussion will focus on the international aspects of geographical indications and the major players that are causing this move away from it just being an EU phenomenon to being a concept and a law that many jurisdictions around the world are now engaging in. Yeah, thank you. Sorry. What's this? Okay, sorry about that. Thank you. Great. So my brief discussion will look at the international law concerning GIs and also the emergence of GI blocks and GI norm entrepreneurs, and also the countries that are, engaging with these jurisdictions. So it could be Canada, it's also CARIFORUM countries, it's also countries in Central America. It's very much global. Renata started off with the concept, looking at the concept of GIs. So the concept of GIs, you can see there are many different products listed there. Some of them are actually agricultural products. There is the basmati rice, which was designated as a GI only just a few years ago in India. There's also soap from India. And there's also soap in France, and the Marseille soap to the very corner over there, where it's not yet designated as a GI, but there's actually talk to have it registered as a geographical indication. And many of the issues that Renata discussed in terms of domestic issues, the stakeholders involved, that is actually going on now in the debates concerning registering the soap in France as a GI. There's also a knife that's registered as a geographical indication in France. Reason being, it was being counterfeited, and it's a traditional form of knife, and they thought that the best way to deal with the issue was to protect the knife as a geographical indication. So France amended their industrial design law in 2015, so that the knife could be protected as a geographical indication. So the concept is, of course, making the connection between the product and the place, and then the law itself is the justification for registering the product based on the connection between the product and the place. Renata spoke about the TRIPS definition of GI, so I won't really talk about that, but it is, as I said, it's the quality, characteristics, reputation of the product. that must be, of course, traceable to the place. That link has to be there. The way how TRIPS has dealt with GIs really is, establishing minimum standards where it can be protected as a certification mark, collective mark. So this is of course under trademark law, or as a generous system of protection, unfair competition law, or as is being done, as being contemplated by CETA, incorporating provisions on GIs into the Trademarks Act. So TRIPS brought about the recognition of geographical indications for agricultural products and foodstuffs. But it was a very minimum standard of protection for these type of products, which are not wine or spirits. And so after TRIPS, what the European Union decided to do was, during the Doha development round of negotiations, was to negotiate for increased protection for GI products. So this would be increased protection, meaning that the name could not be used on any other product, the name cannot become generic, words like such, like, imitation could not be used on the products. So these were EU demands, and they were very strong demands, but of course this is on one side, and then we have the very influential US that totally opposes the recognition of agricultural products and foodstuff as GI. So they totally oppose these in the Doha Round. The Doha Round of negotiation happened for over a period of 8 years, so 8 years or so. By 2008, the talks, nothing happened. The talks were unsuccessful. The negotiations stalled, so the EU decided to do something else different. It was not working on the multilateral stage, so they decided to use preferential free trade agreements, so regime shifting, to get, actually it was not the only reason, right? But what they did really was just to place enhanced protection for geographical indications in their preferential free trade agreements. And I've referred to them really as GI norm entrepreneurs. The idea of a norm entrepreneur is, and this is really going back to IR, international law and international relations theory, where there's an influential actor and they have an interest worth protecting, and they know that there is an identified threat to market access, which is what the EU saw happening with many of their products, and that's why they bargained. They wanted to claw back a number of products, of GI products, during the Doha round of negotiations, which was unsuccessful. So and also the influential actor influencing global interest by a chosen mechanism. So this is of course by preferential free trade agreements. And of course, a change resulting in the country that they're engaging with. And you see this with the EU, but we also see this with Switzerland as well on a lower level, but it's actually pronounced. It's there as well. Let's step back a little bit and talk about why the EU is interested in enhanced protection for agricultural and food-based geographical indications. Over the past century, they've changed their GI laws 3 times, regulation 3 times, and they're very much focused on product quality and also fair remuneration to their farmers. And also, if we think about product quality and fair remuneration, it's really only possible if the consumer that is informed decides that the product is worth buying, purchasing. And so, as Renata rightly said, there's also this emphasis on rural development. So how can there be socioeconomic improvements in the living standards of those persons who are in the GI communities, as well as those persons who are living in proximity to those GI communities. So the EU is very much focused on this type of position where GIs are concerned. And so agricultural products are protected, foodstuff is protected, names cannot become generic, and it's a very expansive legislation. So in terms of, so we see how it works domestically within the EU, and then globally, through preferential free trade agreements, we notice that, okay, so the red section, I'm hoping that you can see this clearly or somewhat clearly. So the red sections are the countries that have implemented EU-based rules on GI through preferential free trade agreements. So this would be Canada. We also look at Central America countries over there, Caribbean countries, and that would be through the CARIFORUM Economic Partnership Agreement. There's also a section of Africa that has implemented the legislation, and the sections in the orangish color are the sections where the provisions are being contemplated through these agreements, but nothing has been finalized. So they're incomplete agreements, such as the TTIP with the US and with India. Now the roadblock really, if we think about the EU-US agreement, is because the US opposes the imposition of geographical indications on agricultural products and foodstuffs. So we can see that as a big roadblock where, for one, within the US, there would have to be a clawback of certain GI product names, which the US opposes. And because they're also very strong players, we can see that more than likely there will be no resolution to this issue. And the blue section really is the GI block. So that's the EU, and that's the protection of GIs within that section. Because of what has been happening, thank you very much. So because of what has been happening, really, there are two approaches. One approach is the increased recognition for geographical indications within domestic jurisdictions. We see this really with, for example, the EPA agreement, or there is just this market preeminence then of certain products. For example, feta cheese in certain jurisdictions. In CETA, for example, where feta cheese is concerned, where the name is concerned, is at least, is that the name, once the agreement comes into force, then the name cannot be used on products that were not in commercial use before October 18th, 2003, right? So that's one. And just think of that as, and then compare it to the Singapore agreement, where the name cannot be used at all, right? So that's a complete retraction of the name. And in the CARIFORUM agreement, it's similar. So we see how important is in terms of the power, the leverage between the parties there. Therefore, that we actually fared better than other jurisdictions where this specific example is concerned. There's also, I've made note of specific agreements like the EU-Ukraine, where there's a total clawback of many product names. And if we think about that practically, it will affect, it has impact on the producer. So it may have economic impact on the producers that are using that name. And there are also legal issues concerned as well. And in regards to, I call these really TRIPS plus provisions. For example, with the Caribbean countries, they had to implement GI legislation by 2014, which is quite interesting. We don't see that in CETA. It's not in the Singapore agreement. It's not in the Central American agreement. So we can see power politics coming into play there as well. That's the EU. Move on quickly to Switzerland. They're quite GI giants. Switzerland has not used preferential free trade agreements per se, but I find it quite interesting and it's quite commendable that they've used bilateral GI agreements. So agreements with Russia, the EU, and Jamaica, where certain products have to be protected. And we also see this in the Switzerland-Japan agreement, Switzerland-China agreement, where it's not just GIs, but Switzerland has also extended it to the Swiss name cannot be used as well. Country names cannot be used, which is quite interesting. And so the EU, Switzerland, US, this is completely different. In the TPP, the Trans-Pacific Partnership Agreement, we see a pullback really on the focus on GI. So the aim was really to ensure that that GIs were not recognized as expansive IP rights. So we see the trademark trumping GI provisions in the TPP, and I spoke about the TTIP as well, and also in the Regional Comprehensive Economic Partnership Agreement, which has yet to be concluded, but there's much indecision there because Japan and India, which have only recently enacted GI legislation and they're doing very well, they've already registered many products. So we see them trying to opposing moves by Australia and New Zealand and other countries to pull back on GI legislation. So we see this, there's no consensus yet on GI provisions in that agreement. And okay, I have no time left, but this is the final slide, so that is good. With all of this now, we just think of the changes to the Trademark Act, and does it provide a strong base for the development of Canadian GIs, which is something that Renata spoke about, and with renegotiations to the NAFTA agreement, we know that because the US opposes GIs because of their traditional and established trademark industries, what is the likely outcome? We know that it will more than likely be contested. And Renata spoke about the fact that there's not a level playing field between the number of GIs protected on ACETA and the fact that there's none protected for Canadian-based products. And then we think about Brexit as well, and what does a UK GI legislation look like? Is there one? What's the degree of trade between Canada and the UK? And how does that, or will that impact Canadian GI producers who are interested in using that system compared to the EU legislation? Thank you. These are questions that are very engaging, and it deserves discussion. It's good that we have this forum to discuss it. Thank you.
Thank you very much, Marcia. I hope that you're accumulating all these questions and things so that we can have a lively conversation as we turn to our final panelist here today, Mr. Jean-Philippe Mikas from Fasken Martineau. And he is going to be speaking to us on geographical indications, appropriation and reappropriation of tradition in the food industry through international agreements.
Thank you very much. I'll just get this. Which button is this? Okay, I won't repeat my title. It's a bit of a mouthful. But let's just hop into this. Obviously, we're talking about food here, and in Canada is a country built through immigration. So food is a key part of the culture brought from abroad, and local industry over time developed to cater all of these needs. And through this catering, there has been either collective appropriation, where unrelated traders have used the same term, it's become essentially a generic term, or private appropriation, and there are some instances of where certain food products or certain names of European origin were appropriated by certain private traders. And European foods are a key part of this, and it's normal that this was a central and very controversial issue in CETA. Now, it's about food, but let's talk about concepts, and let's talk about trademarks and geographical indications, how similar are they? What are they? They're both used by traders, and obviously we can all talk about enhancing the social benefit for agricultural, for farmers or people who are in that industry, but they are used by traders, both used by traders. But they're very different beasts. It's like comparing a horse and a unicorn, right? In fact, it's even more complicated because in Bill C-30, there's actually two types of unicorns. There are regular GIs, regular geographical indications, which can be challenged on the basis of confusion with prior registered, applied for, or unregistered trademark rights, or that can be opposed or objected to on the basis that they're a customary term. And there are what I would call super GIs, which are the listing of which cannot be challenged on the basis of other trademark rights or the fact that they're a customary term. And it's a mistake to think to assimilate these geographical indications to official marks or other restrictions under Section 9, because they're really for conducting trade. And the GIs, as was mentioned earlier, their nature flows from the quality, reputation, or other characteristics essentially attributable to a geographical origin. So whether those aspects are known or unknown to Canadian consumers is entirely irrelevant in this whole system, especially for super GIs. And preventing actual confusion can't really be an objective because there's no requirement that they be really distinctive. So, and in GIs, often the focus is on the interests of a multitude of unrelated traders in a particular region. That's it, not necessarily control by a certain entity. I mean, there are, of course, certain established characteristics, practices, or traditions in the geographic location that must exist, otherwise it can't be really a GI. So this is really at odds with our horse here, which is just a regular trademark, which the objective of which is to indicate the source of control over the quality and character of goods or services of person. You know, trademarks must remain distinctive and not be generic, and protection may be lost if unused. So, in fact, we've inserted these GIs in the Trademarks Act, but the objective of the Trademarks Act has been stated by the Supreme Court to provide an assurance to the consumer that the quality will be what he or she has come to associate with a particular trademark. It is, in that sense, consumer protection legislation. But in this case, sometimes the consumer won't have any specific expectation because it has to do with their reputation in a local foreign market and not necessarily the recognition or acceptance of these particular qualities in Canada. So no wonder, so even super GIs are even further removed, because even if it's a customary term, it doesn't really matter, which is what has been referred to as clawing back, right? It's no wonder that the protection of GIs in the US, in part, was incorporated into marketing and labeling laws, not trademark law. And in fact, in C-30, if my recollection is correct, GIs are not even included in the definition of trademark. So now we have a Trademarks Act that has horses and unicorns, which makes it a bit difficult conceptually. And in fact, when this Bill C-30 will be enacted, the only GIs that will exist are super GIs. And new super GIs may be adopted by simply modifying or amending the schedule to the international agreement without any court-mandated process to formulate objections. So essentially, super GIs are the fruit of an arbitration of commercial interests at the state level, and that's about it. So conceptually, very different. So, how will super GIs be received in Canadian trademarks law? So they will be parachuted in the Canadian trademark system with an approach that's very similar to Article 9 of the Act, even though, as I mentioned, the interests are not exactly the same because we're talking about the interests of traders. So it is a provision that essentially forbids others from using the term within the same category of products. And this automatically results in one of two outcomes. Either one, option A, an instant reappropriation of the term that's in common use by multiple traders. So consumers will be perhaps forcefully re-educated or educated to understand that that this name has geographical origin and there are some merits to this particular geographical origin. Obviously, in terms of consumer education or protection, this may or may not work. Perhaps consumers will never realize that this is a geographical name or it has a particular meaning or quality or tradition associated with that name. But of course, being a super GI or being a geographical indication, even though it's in the Trademarks Act, this is essentially irrelevant to maintaining protection because distinctiveness is not essentially required to maintain protection for a GI. And in certain cases, due to compromises in the negotiation of the international trade agreements, the re-education or reappropriation is only partial, where certain people who have certain vested commercial interests will be able to continue to use if they use prior to a certain date. And in certain cases, it's only partial. For example, brie remains generic, but brie de meaux becomes a reserved term. So essentially, it becomes complex to understand what exactly will be going through the minds of the consumers. So essentially, we're really moving away from a consumer perception-based system to be essentially to an arbitrary system where we're imposing certain views or certain things. Now, there are some accommodation to consumers, like for example the permission to use Feta style or Munster type or Asiago imitation, and this is only for certain. There's about I think only 5 terms, agricultural terms, where you can use style type imitation, and other than that, the others you cannot use this particular function. So this was result number 1. You're taking essentially something that was common property or common in the common a common good that was shared by all traders. The other possibility is, well, there may be conflict with persons who could claim to have previous exclusive rights over the term. So either registrations or rights acquired through common law use, because obviously the focus of the Canadian trademarks registration process or passing off has been on what do Canadians think? Do they think that it designates an exclusive one origin, but the origin is a trader in Canada, or does it designate a geography? And this second situation raises an interesting question. So do super GIs prevail over pre-existing rights, or do they merely coexist with them? Bill C-30 on that front essentially excludes the application of the grandfathering provision in a case of super GIs, which protects essentially for normal GIs, prior users, applicants, or registrants. And what may flow from this exclusion is that the existing owner of a trademark right could be forced to cease use. But then the reverse must be taken the converse must be taken into account. What then happens with existing trademark rights, either rights that exist under the common law or rights that exist under registrations? Bill C-30 doesn't really clearly address this. Since the provisions are modeled on Section 9 of the Trademarks Act, which are essentially restrictions preventing traders to do certain things, as I've stated before, I mean, we're talking about GIs are signs that are used by traders, not signs that are excluded from trade on behalf of people who are not traders. So because the choice has been made to use a system similar to Section 9, essentially it's not like in Section 19 of the Trademarks Act, where essentially it has been interpreted by the courts as being a positive right to use the name. So essentially the trader, someone who registers a trademark, essentially has a positive right to use, and which has been recognized by several decisions where they've said essentially that the trademark registration can serve as a shield, which may not be the case under Section 9 because the language is not exactly written in the same manner. So there may be no positive right to use a super GI, so which may mean that which could mean perhaps that persons having an enforceable trademark right may exclude from the marketplace products bearing super GIs and perhaps claiming profits, damages, or even an injunction due to passing off or infringement. And there's no clear statement in Bill C-30 on whether prior trademark rights are really extinguished. So this portion of reappropriation hasn't really been directly addressed. So essentially, if this happens, the implementation of some super GIs could result in simply a stalemate in the marketplace. The last point is, so what of European geographical indications that did not make the list of super GIs? What happens to them? Obviously, their fate is more uncertain because they're vulnerable to attack on the basis of prior trademark rights or common use in Canada if they fall in the regular GI process. They could obviously lobby and try to be included in the trade agreement, which could be a challenge. They could also attempt to obtain recognition as a certification mark if there's use in Canada, as this is currently a requirement. But the same difficulty exists if there are pre-existing rights or there's no distinctiveness in Canada. This creates an issue. And of course, obtaining standard trademark protection has become quite difficult since the MC Imports versus AFOD case in 2016, where essentially the Federal Court of Appeal has caused some upheaval in the world of geographical names because pursuant to this decision, the mere fact that a geographical name is the place of origin of a product precludes trademark protection entirely, unless acquired distinctiveness is proved. So it's irrelevant in this particular situation whether Canadians have any particular knowledge of the geographical location or the fact that the products at issue originate from this geographical location. So for foreign authorities seeking to protect their GIs in Canada, this may turn out to be, in a sense, a boon because it will make it very difficult for local traders to monopolize the geographical location through a trademark application in Canada. And this development actually may avoid clutter on the register with a bunch of traders trying to grab trademark rights for geographical names that are not necessarily known at this point in time by Canadians. Applications for certification marks and the new GI regime are not affected by this restriction because explicitly certification marks can be used to designate a specific location and it's part of their function. So this is not an issue. The only issue is that a pending application or prior use may be the basis for objecting or opposing. Obviously, the application must remain pending, which may be an issue with the Trademarks Office. But as you may know, it's possible to argue for years with the Trademarks Office. So who knows? Some GI application, regular GI applications may be held up. And the prior use must be as a trademark, which really haven't figured out yet whether using a geographical name due to the AFOD case, will that be considered use as a trademark or will that fall into use as a name that does not have trademark significance? So we see with this development that the Trademarks Act is evolving in a manner that's a bit similar to the Copyright Act with ad hoc arbitration of interests. And with what we've seen here, we've essentially are introducing in the Act we're really starting to have a very wide variety of beasts that are inhabiting this particular space, and it's going to soon become very, very difficult to get a firm grasp on the theoretical underpinnings of trademarks law. It may have been easy a few years ago for the Supreme Court to state exactly what was the purpose or the aim of trademarks legislation, but it may be a challenge if we're before the Supreme Court in a couple of years to essentially state what is the theoretical underpinning. And it's this recent development with GIs makes it very difficult. And thank you for the 0 time. My comments are complete. Thank you very much.